You've done everything right. You set up a trust, named a trustee, and outlined your wishes. But there is one critical piece most people miss, and it's the one that can cost your family everything. It's not about what's in the trust. It's about how money comes out of it. Here's the hard truth. If you or your trustee don't follow the right rules for accessing those trust funds, you could accidentally open the door to creditors, trigger unexpected taxes, or even allow ex-spouses or lawsuits to drain what was meant to be protected. In this video, I'm going to show you how to access trust money the smart way without putting your plan, your assets, or your family at risk. Let's dive in. Here's the reality most people miss. Just because your assets are inside the trust doesn't mean they are protected. The real power of your trust comes down to how those assets can be accessed. That's determined by the words in your trust documents. Words most people skim over or don't fully understand. Those few words might seem like small details, but they determine everything. Who gets what, when they can get it, and whether creditors, courts, or tax authorities can get involved. Let me make this real for you. Imagine you've built a beautiful vacation home in the mountains. Toll gates, alarm systems, surveillance cameras. But you left the back door wide open. It doesn't matter how strong the structure is if someone can just walk in. That's what happens when your trust distribution language is too vague, too flexible, or simply poorly written. Some trusts require the trustee to hand out all income every year, even if the beneficiary doesn't need it. That's called a mandatory distribution. Others give the trustee full discretion to decide if and when distributions happen. Here's the kicker. Depending on how your trust is worded, a beneficiary might actually be able to force a distribution. And once the door is open, guess who else comes knocking? Creditors saying, if your son can access this money, then we have a right to it as well. Ex-spouses arguing that trust assets are part of a divorce settlement. Or even the IRS counting those assets in someone's taxable estate. It happens all the time. I once spoke with a person who set up a trust for his adult children. He thought he'd done everything right. Years later, his son went through a divorce. And because the trust gave the trustee broad discretion to make distributions for any reason they see fit, that flexibility backfired. The ex-spouse's attorney successfully argued that the trust money should be included in the divorce. Hundreds of thousands of dollars were lost because the trust was written with too much freedom and not enough clarity. That's why understanding how trust money can be accessed isn't a legal footnote. It's the foundation of your entire estate plan. So how do you allow your family to access trust money when they need it while still protecting those assets from lawsuits, taxes, or bad decisions? That's where something called ascertainable standards comes in. Okay, I know the term sounds like legal jargon, but stick with me, because this is the key to getting it right. Ascertainable standards are simply rules inside your trust that say, yes, the trustee can give money to the beneficiary, but only for specific, clearly defined reasons. They are like clearly marked exits on a highway. Instead of giving your beneficiaries a steering wheel and saying go wherever you want, you are saying you can leave the road here, here, and here, and only if you really need to. The most common and safest standards are called HEMS, which stands for Health, Education, Maintenance, and Support. Let's walk through each of them in plain English. The health standard means the trustee can approve funds to cover medical needs. We are talking doctor's visits, hospital bills, prescriptions, therapy, health insurance premiums, and in some cases even wellness programs or home care. So if your daughter, who's the beneficiary, needs funds for surgery or rehab or even a mental health program, the trust can allow that without compromising the structure. The education standard is pretty self-explanatory. It covers school, from college to trade programs, and everything that comes with it. Tuition, books, supplies, housing, and even study abroad. If your grandchild wants to go to law school or become a chef, this standard can help them do it without giving them unrestricted access to the trust. Maintenance and support go hand in hand and allow the trustee to provide funds that help the beneficiary maintain their standard of living. We are not talking luxuries or lottery winnings. We are talking everyday life, housing expenses, property taxes and insurance, groceries and utilities, clothing, reliable transportation, reasonable travel, even ongoing charitable giving if that's been part of the beneficiary's life. Here's where it gets interesting. Courts have generally ruled that support isn't just about survival. It can mean sustaining a beneficiary's existing standard of living. That's why this standard is so widely used. To see how this plays out in everyday life, here's a simple example. Say your adult son is both trustee and beneficiary. He needs money from the trust to repair a roof, pay for his daughter's braces, buy a luxury SUV. Under a properly written HEMS trust, the roof repairs and the braces absolutely allowed. The luxury SUV, not unless it's medically necessary. That's the power of using clear, purpose-driven standards. You preserve control, protect your assets, and still provide for legitimate needs, all while keeping courts and creditors out of the picture. And here's why this matters for you. If your trust doesn't clearly define these limits, you might think your money is protected, but it's not. Understanding these standards is the first step, but making sure your estate plan actually protects what matters most is just as important. If you'd like help reviewing your plan from a financial perspective to make sure everything works together the way you intend, feel free to schedule a no-obligation estate clarity meeting using the link below. Ascertainable standards aren't just about giving trustees better guidance. They're about protecting everything you've worked for. When done right, they give you 4 powerful benefits. Number 1, asset protection. Let's say your child is both the beneficiary and the trustee. That could look risky. They are managing their own trust and distributing to themselves. But if their power to distribute is limited to HEMS and clearly written, courts have ruled that creditors cannot force them to make distributions. The trustee has a duty to follow the standard, not personal desire. Without this safeguard, a creditor could argue, your child can take money out for whatever they want, so hand it out. That's how poorly drafted trusts get pierced in lawsuits. Ascertainable standards stop that. Number 2, income tax efficiency. The IRS also cares who is treated as the owner of trust assets for income tax purposes. In some cases, a trust maker might reserve the power to distribute income, but if that power is limited by HEMS, they may not be treated as the owner for tax purposes. This keeps the trust off their income tax return and keeps the tax liability where it belongs. Number 3, preventing overspending and family drama. Let's be honest, not every beneficiary is financially responsible. Without limits, some heirs might burn through their inheritance in record time. Worse, family members may start fighting over who gets what and when. But when the trust is clear, decisions feel less personal and more professional. Instead of "Dad said no," it is "Here's what the trust allows." Clarity prevents conflicts and structure builds legacy. Number 4, estate tax avoidance. If your trust gives a beneficiary or trustee too much power, like saying they can distribute funds for comfort or pleasure, the IRS may treat those assets as part of the beneficiary's estate. And that could mean a massive estate tax bill down the road. The trust assets might be taxed when the beneficiary dies, or trigger gift taxes if passed to someone else. But when distributions are clearly limited by HEMS, the IRS sees it differently. In most cases, the assets stay outside the estate, and that could mean saving your family hundreds of thousands in taxes, simply by using the right words. Okay, now here's where things get dangerous. Even if your trust includes HEMS language, there is one thing that can ruin all those protections, and most people don't even realize they've done it. A general power of appointment gives a person, often the trustee or beneficiary, the ability to distribute trust funds to themselves, to their estate, or to their creditors. This kind of unrestricted power defeats the purpose of a trust entirely. It can open door to estate inclusion at death, creditor claims during life, when money is passed between generations. And here's the tricky part. The power can sneak in through vague or casual language like the trustee may distribute for the beneficiary's comfort or happiness, or distributions may be made in the trustee's sole discretion for any reason. These phrases sound harmless, but they create exactly the kind of unlimited discretion the IRS and courts look for when deciding whether trust protections apply. That's why HEMS exists. It creates a clear, measurable standard, one that courts recognize, and that keeps your trust assets protected where they belong. The truth is, most people don't realize how easy it is to break the protections they thought a trust provided. They assume the paperwork is enough, but it's the fine print around access and discretion that makes all the difference. Getting this right means your family gets real protection, not just in theory, but when it matters most. It means fewer surprises, fewer fights, and a plan that actually holds up under pressure. So whether you already have a trust or you are thinking about creating one, remember, it's not just about having a plan, it's about having the right one. Now that you know how to access trust funds the right way, there is another critical piece you can't afford to miss. Did you actually move your assets into your trust the right way? In this video, I show you the big mistake people make when setting up their trust and how one simple oversight can leave your entire plan vulnerable. Please check it out to make sure your trust is fully protected.